Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Wednesday, October 12th, the real Columbus Day, 2022. It's about 11:40 in the morning here on the East Coast of the United States. One of former President Donald Trump's lawyers is now becoming a witness against him in the criminal investigation of retention of national defense information and obstruction of justice with respect to the national defense documents and the big brouhaha at Mar-a-Lago, the former president's home and private club in Palm Beach, Florida. Now, how can this happen? Okay, so this young lawyer, Christina B-O-B-B, signed a statement which was submitted to the Department of Justice. She signed it under oath, saying that a diligent search for the documents that the government sought was made, and as far as she understood, all the documents had been surrendered. Of course, we know that all the documents had not been surrendered because that statement, which was made under oath and submitted to the feds, preceded the FBI execution of a search warrant at former President Trump's home, which produced another 100 documents in that same category. So the question is, who told her that? She spent last weekend answering questions under oath before federal prosecutors. And apparently she told those prosecutors that another lawyer, Evan Corcoran, told her that. So she now believes, and the feds now believe, that either Mr. Corcoran and the president misled her, or the president misled Evan Corcoran. But she made, Christina Bob, the one who signed the sworn statement, she made a material misrepresentation to the federal government. If it was intentional, she'll be prosecuted for obstruction of justice and perjury, lying under oath. If it was not intentional, and it appears as though it was not, then she's going to help the feds find out who is or what was the source for that information in the affidavit. Now you might say, well, she was Trump's lawyer. How can she possibly testify against him? That's a great question, because there is, of course, the attorney-client privilege. Now, that's a privilege that belongs to the client, not to the attorney. So the client, the former president himself, would have to say, I don't want you testifying. I don't want you communicating anything that you learned in the course of your work as a lawyer for me. She's not an outside lawyer for Trump. She's an in-house lawyer whose office is there, who works full-time for him. However, there's an exception to the attorney-client privilege for deception and fraud. If the client uses the attorney to perpetrate a fraud, or if the attorney knowingly deceives someone in behalf of the client, then there is no attorney-client privilege and the attorney can be compelled to testify. That is apparently what happened here. She either made this material misrepresentation knowing, or she was duped by either one of her other colleagues or the former president himself into making this statement. Either way, there's either deception or fraud, and so there's no attorney-client privilege. We don't know if Trump tried to stop her from testifying, but we do know what that exception is. It's a large exception. When I went to law school, that exception did not exist. The attorney-client privilege was absolute. Today, it is not absolute. There is that large, like a donut with a hole, there is that large hole in it for deception and fraud. Now, what did she tell the feds? We don't know. Apparently, she has not yet testified before a grand jury. She just was interviewed by federal prosecutors who probably will want her testimony before a grand jury. Does she still work for Trump? I doubt it, but we don't know. I mean, this just happened Friday and Saturday last weekend. We don't know if she's back in Florida now. She was in Washington, D.C. when these interviews occurred. I've been saying this before, and I'll say it again. Donald Trump is in grave legal peril. When your own lawyers are called as witnesses against you, the situation is very, very grave. when the only reason the feds are not asking a grand jury to indict you is because we are 3 weeks out from election day. The only reason. The situation is very, very grave. Meanwhile, the existence of the special master, that issue is before the Supreme Court of the United States. The law as it currently stands, the most recent ruling, which is the United States Court of Appeals for the 11th Circuit, sits in Atlanta, but covers Alabama, Georgia, and Florida, is that the special master is in place. He is not reviewing the classified documents or the documents marked classified or the documents that contain national defense information. And the feds, the Department of Justice, and the FBI are able to use those documents to show them to witnesses and to show them to the grand jury. If the Supreme Court intercedes, then whatever it says will be the final word on this. My prediction, and that of most lawyers who've looked at this across the board, liberal, conservative, Republican, Democrat, libertarian, progressive. I guess you got to get all those monikers in these days, have nearly universally agreed that the court is not going to get involved in this. Trump's motion for a special master has ended up biting him in the rear end and costing him more money than he ever imagined. More on this as we get it. Judge Napolitano for Judging Freedom.